Say these words if Florida police come to your door. When Florida police knock on your door, most people make the same catastrophically expensive mistake. They open it. This video gives you the exact words to say, breaks down your Fourth Amendment rights under Florida law, and explains the critical difference between a warrant, no warrant, and a welfare check at your front door. When Florida police come to your door and they knock without a warrant, most people make one mistake that changes everything. They open it. Teresa Brandt was a teacher in Hillsborough County. 2 officers knocked on her door. Neighbor complained. "Can we step inside for a minute?" said the police. She said, "Sure, come on in." 3 days later, they came back with a warrant, built on what they saw during a visit she never had to allow. I'm John Musca. I've been defending Floridians for over 25 years. I'm going to give you the exact words to say when Florida police knock on your door so you don't make Teresa's mistake. What the law actually says about your front door. Here is the single most important legal fact you will learn today. Your home is the most constitutionally protected place in the entire legal system. The Fourth Amendment to the United States Constitution protects you against unreasonable searches and seizures. Courts have recognized for over 2 centuries that nowhere receives stronger protection than your private residence. A man's home is his castle is not just a saying, it's a principle embedded in American constitutional law. In Florida, when police come to your door without a warrant, they have no legal right to enter, period. Full stop. They can knock. They can stand on your porch. That's a public access point, and they're permitted to be there. But the moment an officer steps past your threshold without your consent and without a valid warrant, they have violated your constitutional rights. Here is the piece most people miss. You do not have to open the door. You are under no legal obligation to answer police at your door. You can remain completely silent, or you can speak through the closed door. And speaking through a closed door does not waive your Fourth Amendment rights. The door stays closed. Your rights stay intact. Your home stays protected. Teresa opened the door. That single decision, made in a moment of wanting to seem cooperative, handed officers everything they needed. The door is the line. Know where it is before they knock. The 3 scenarios at your front door. When police knock on your door, there are 3 situations, and your response should be completely different in each one. Scenario number 1, they have no warrant. This is the most common situation and the one where most Floridians give up their rights without realizing it. Once officers knock, they say they want to ask a few questions. They mention a neighbor complaint. They say they're doing a wellness check. Maybe they don't explain anything at all. Without a warrant, you have zero obligation to open your door, answer questions, or allow anyone inside. Zero. Under Florida law and federal constitutional law, that point is very clear. The right move is to stay inside. If you choose to say anything, speak through the closed door. Here are the words you should say. I cannot speak to you without an attorney present. If you have a warrant, please slide it under the door or hold it to the window. That is it. Those 2 sentences. Don't add explanations. Don't say I'm not trying to be rude. Don't ask, what is this all about? That question opens up conversation. Every word beyond those 2 sentences is a word that can be turned around later and used against you. Scenario number 2, they have a search warrant. A search warrant is a court order. The judge reviewed probable cause and authorized officers to search a specific location for specific items. If they have a valid search warrant, they are legally permitted to enter your home. Under Florida law, officers executing a search warrant must knock, announce their authority and their purpose, and wait a reasonable time before entering. Only if they are refused entry, or if their entry is unreasonably delayed, can they then force entry. If officers say they have a search warrant, do not open the door yet. Ask them to hold the warrant to the window or slide it under the door. Read it. Confirm your address appears correctly. Confirm what it authorizes them to search. Remember, a warrant for a specific item does not grant blanket authority to search every corner of your home. Scope matters enormously. Once you've confirmed the warrant is valid, do not resist, do not obstruct, but do not answer any questions under any circumstances. Do not volunteer any information. The moment you've confirmed the warrant, call an attorney before you say another word. Scenario number 3, they have an arrest warrant. An arrest warrant names a specific person. If that warrant is for you, officers are legally permitted to enter your home to take you into custody even without a separate search warrant. If the warrant names someone else, they need that person's consent or additional legal authority to enter. Same process. Ask to see the warrant through the window or under the door. Read the name. Read the address. Check the date. Errors in warrant details matter. Tell your attorney everything you observe, whether it's a search warrant or an arrest warrant. Confirm it. Comply physically, and then close your mouth and open your phone to call a lawyer. The wellness check. Law enforcement's most misused tactic. Let me talk about something that catches Floridians completely off guard. The welfare check. Officers understand exactly what they can and cannot do without a warrant. They also know that most people will hesitate to keep a door closed when an officer says, "We just want to make sure you're okay." Welfare checks can be legitimate. A family member calls police because they haven't heard from someone in days. A neighbor reports an elderly resident who hasn't answered their door. Those are real situations. But the wellness check has almost become one of the most commonly used pretexts or excuses to pressure residents into granting warrantless entry. And Florida courts have not looked kindly on that tactic when it is abused. Here is what the highest court in the country has said. United States Supreme Court ruled in Caniglia versus Strom that there is no blanket community caretaking exception that automatically allows officers to enter your home without a warrant during a wellness check. The home is different from a car, different from a street, different from anywhere else, and the protections that apply there do not dissolve just because the officer knock and frame their visit as a welfare matter. Under Florida law, if officers claim there are emergency circumstances that justify entering your home without a warrant, the burden is on the state to prove that emergency was real and immediate. Florida courts define those emergency justifications narrowly. Genuine imminent threat to life, active destruction of evidence, hot pursuit of a fleeing felon. A vague complaint from a neighbor does not qualify. Officers wanting to take a look around does not qualify. A door that went unanswered for an hour does not qualify. If officers arrive at your door and tell you it's a wellness check, you do not have to open the door to satisfy them. Speak through the door. Say the words, "I'm fine, thank you. I cannot speak with you further," without an attorney present. You have confirmed your safety. In that case, you have not consented to entry. You have not waived a single right. And if they are genuinely concerned for your well-being, that statement addresses it completely. Why nothing to hide is the most dangerous phrase you own. Here's what Teresa told me when she first called our office. "I figured if I had nothing to hide, I had nothing to worry about." I hear this constantly, and it's the most dangerous assumption you could carry to your front door. When officers step inside your home, even with your permission, even on a friendly visit, anything they observe in plain view can become the foundation for probable cause. A prescription bottle on the counter, a piece of equipment, a smell, a sound coming from another room. Anything they see or hear legally observed during a consensual entry can justify the next step, and the step after that. You did not do anything wrong. You consented to a visit. Officers lawfully observed something. They took it to a judge. A judge signed a warrant, and now your private life is an open investigation. Teresa didn't break any laws on that Tuesday evening, but she handed officers a window into her home that they used to build a legal foundation for everything that followed. This is why the door matters so much. Not because you have something to hide, but because you have rights worth keeping, and keeping that door closed is the simplest, most powerful way to exercise them. The exact words, say these, nothing else. Write these down, put them in your phone, tell your family. If police knock and you do not know whether they have a warrant, say this: "I cannot speak with you without an attorney present. If you have a warrant, please slide it under the door or hold it to the window." If they say it's a wellness or welfare check, you say, "I'm fine, thank you. I cannot speak with you further without an attorney present." If they say they have a warrant, you say, "Please hold the warrant to the window so I can read it." Confirm the address and the names are correct. Note what it authorizes. Then comply physically and call an attorney before you say one more word. These are not hostile phrases. These are constitutional ones. You are not obstructing anything. You are not escalating anything. You are exercising rights that were specifically designed to protect you in this exact moment. Rights that generations of Americans fought hard to preserve. What Musca Law did for Teresa. Teresa called us on day 4. By then, the warrant had been executed. We immediately began reviewing the chain of events, the initial visit, what officers documented, how the warrant application was written, whether their observations from the consensual entry were characterized accurately. We found what we needed. The warrant's foundation was significantly weaker than it appeared, and the way the initial visit was framed in the warrant application raised serious issues. We challenged the evidence. Several key items were suppressed. 8 months later, Teresa's case was resolved with no conviction. She kept her teaching license. She kept her career. She called me after it was over and said, I just wish someone had told me 4 words before any of this started. I know what 4 words those were. Don't open the door. If police already come to your door, whether you opened it, whether you answered questions, whether a warrant came later or not, call us. The conversation is free. And what we find in that conversation may be the most valuable thing you've ever done for yourself. Musca Law has offices throughout Florida, and we answer calls 24 hours a day, 7 days a week. The time to call is before your next mistake, not after it. The next video in this series covers another situation where knowing the right words can change everything. If you've ever had a Florida officer tell you they can smell something, watch it next. I'm John Musca, and I'll see you in the next one.